Florida GRANDE, petitioner, versus Philippine Nautical Training College, respondent, GR number 213137. Facts. Respondent Philippine Nautical Training College, PNC, is a private entity engaged in the business of providing maritime training and education. Respondent employed petitioner from 1988 until 2011. In February 2011, several employees of Respondent's registration department, including the VP for Training Department, were placed under preventive suspension in view of the anomalies in the enlistment of students. On March 1, 2011, the VP for Corporate Affairs, Frederick Pios, called petitioner for a meeting. Pios relayed to petitioner the message of PNC's president, Attorney Hernani Fabia, for her to tender her resignation from the school in view of the discovery of anomalies. Pios assured petitioner of absolution from the alleged anomalies if she would resign. Petitioner then prepared a resignation letter, signed it, and filed it with the office of the PNC president. The respondent accomplished for her the necessary exit clearance. The resignation letter of petitioner reads, Attorney Hernani Fabia, President, Philippine Nautical Training Institute. Sir, this is to officially file my resignation effective March 2, 2011 as Director for Research and Course Development / AVP. Thank you. Signed, Florida GRANDE. In the evening of the same date, petitioner filed a police blotter for a complaint for unjust vexation against Pios. The next day, March 2, 2011, petitioner filed a complaint for illegal dismissal with prayer for reinstatement with full back wages, money claims, damages, and attorney's fees. In her position paper, petitioner alleged that she was forced to resign. On the other hand, respondent claimed that petitioner voluntarily resigned to evade the pending administrative charge against her. Issue: whether or not the petitioner was forced to resign from her post, thus illegally dismissed. Held: yes. Resignation is the voluntary act of an employee who is in a situation where one believes that personal reasons cannot be sacrificed in favor of the exigency of the service, and has no other choice but to dissociate from employment. To determine whether the employee indeed intended to relinquish such employment, the act of the employee before and after the alleged resignation must be considered. The court concurs with the findings of the NLRC that the acts of petitioner before and after she tendered her resignation would show that undue force was exerted upon petitioner. 1. The resignation letter of petitioner was terse and curt, giving the impression that it was hurriedly and grudgingly written. 2. She was in the thick of preparation for an upcoming visit and inspection from the Maritime Training Council. It was also around that time that she had just requested for the acquisition of textbooks and teaching aids, a fact which is incongruent with her sudden resignation from work. 3. In the evening, she filed an incident report / police blotter before the Intramuros police station. And 4. The following day, she filed a complaint for illegal dismissal. In order to withstand the test of validity, resignations must be made voluntarily and with the intention of relinquishing the office, coupled with an act of relinquishment. Therefore, in order to determine whether the employees truly intended to resign from their respective posts, we must take into consideration the totality of circumstances in each particular case. We emphasize that petitioner filed her complaint against the respondent in the NLRC the day after she tendered her resignation. Indeed, voluntary resignation is difficult to reconcile with the filing of a complaint for illegal dismissal. The filing of the complaint belies respondent's claim that petitioner voluntarily resigned, as held by this court in Valdez v. NLRC, which was reiterated in the case of Fungo v. Lourdes School of Mandaluyong. It would have been illogical for herein petitioner to resign and then file a complaint for illegal dismissal. Resignation is inconsistent with the filing of the said complaint. Petitioner's intention to leave the school, as well as her act of relinquishment, is not present in the instant case. On the contrary, she vigorously pursued her complaint against respondent. It is a clear manifestation that she had no intention of relinquishing her employment. The element of voluntariness in petitioner's resignation is, therefore, missing. In termination cases, burden of proof rests upon the employer to show that the dismissal is for a just and valid cause, and failure to do so would necessarily mean that the dismissal was illegal. In Mobile Protective and Detective Agency versus OMPAD, we ruled that should the employer interpose the defense of resignation, it is incumbent upon the employer to prove that the employee voluntarily resigned. On this point, respondent failed to discharge the burden. Respondent's eventual act of resigning and thereafter causing the matter to be recorded in the police blotter are appreciated as a well-thought-out plan carried out in order to preempt the investigation conducted by petitioner. In fact, right after she tendered her resignation, respondent wasted no time in obtaining a clearance from the different offices of petitioner, which left the latter with no sufficient time to verify if she had a hand in the illegal schemes. As correctly observed by the labor arbiter, petitioner's resignation immediately tendered after the conversation is not voluntary. With an order coming from the president of P&C, no less, undue influence and pressure was exerted upon petitioner. Petitioner declared in her petition that she felt lambasted when she was told about the order of P&C president for her to resign considering her exemplary performance in the school. She narrated that when she returned to the school in July 2009 as director for research and course department, the offered courses of the school rose from 29 to 48 courses. As in fact in 2010, she was offered the position of assistant vice president for training department. These statements of petitioner were not disputed by respondent in its comment to the petition. Clearly, her consent was vitiated. It must be noted that she was not among those preventively suspended in February 2011, which include the vice president for training, in view of the ongoing investigation in the registration department. We, therefore, believe that petitioner felt the undue pressure exerted on her to resign from employment despite her exemplary performance and having served the school for years. We agree with petitioner that she was then without proper discernment when she prepared the one-liner resignation letter. Also, as a sign that respondent really wanted petitioner to go is the fact that the former immediately issued the latter her clearance showing the signatures from different departments of the school. If petitioner was being investigated for an administrative charge, why was she cleared from liabilities? In the case at bar, petitioner's letter of resignation and the circumstances antecedent and contemporaneous to the filing of the complaint for illegal dismissal are substantial proofs of petitioner's involuntary resignation. Furthermore, in an illegal dismissal case, the onus probandi rests on the employer to prove that the dismissal of an employee is for a valid cause. Having based its defense on resignation, it is incumbent upon respondent, as employer, to prove that petitioner voluntarily resigned. From the totality of circumstances and the evidence on record, it is clear that respondent failed to discharge its burden. We have held that if the evidence presented by the employer and the employee are in equipoise, the scales of justice must be tilted in favor of the latter. Under Article 279 of the Labor Code, an employee unjustly dismissed from work is entitled to reinstatement and back wages, among others. Reinstatement restores the employee who was unjustly dismissed to the position from which he was removed, that is, to his status quo ante dismissal. While the grant of back wages allows the same employee to recover from the employer that which he had lost by way of wages as a result of his dismissal. The court ruled in favor of the petitioner declaring that she was illegally dismissed,